court is now in session. Please be seated.
Thank you, Madam Clerk. Call the next case, please.
State of Tennessee versus Ronald Andrew Archey.
All right, you ready, General?
Yes, Your Honor. May it please the court, Alan Gross for the state. I'd like to reserve 3 minutes for rebuttal this time.
Certainly.
The state sought interlocutory review in this murder case because the trial court erroneously granted Archey's motion to suppress cell phone data that was collected pursuant to a search warrant. This court should reverse because the search warrant was supported by probable cause, and alternatively, officers' good faith reliance on the warrant should bar application of the exclusionary rule. I want to begin by addressing the issue of probable cause, and specifically, I want to highlight 3 general principles that govern this court's review of this issue. First, the court's standard of review is whether the magistrate's decision finding probable cause, whether there was a substantial basis to support that decision based on the entire evidence in the record. So second, we're looking at the totality of the circumstances that are in the search warrant affidavit when we're considering the existence of probable cause. And third, we have to look at this affidavit in a common sense and practical manner. I think it's really important that we keep those general principles in mind. And here, as I've said in my brief, I think there's really 4 different categories of facts that we can pull out of this search warrant affidavit to establish probable cause. And I want to emphasize before I get into these 4 different categories that the state's position is not that any one of these particular facts is enough standing alone to support probable cause. What we're saying is that when you look at all of these facts as alleged and taken them together, the totality of the circumstances supports a reasonable inference that the cell phone contained evidence of these crimes. So the first fact that I want to focus on is the timing of Archey's cell phone use around the time of the murders. And the search warrant affidavit explains that when law enforcement approached Archey's girlfriend to interview her about what she knew, she gave law enforcement officers permission to look at her phone, and when they scrolled through her phone call log, it showed that there were several occasions on the day before the murder and the day of the murder where she had been in contact with Archey using his cell phone. So that's immediate, direct proof that we know Archey was using his phone in close temporal proximity to the time of the murders. We also know that Archey contacted the sheriff's department later on in the day on September 19th, presumably using his cell phone. And we also know, based on his police interview, when he briefly gave his phone to law enforcement to look at, that he made several calls using Facebook Messenger on his phone shortly after the murders. So all these facts that are included in the affidavit show that he was using his cell phone very close in time in comparison to the murders, both before and after. So that's one data point that the magistrate had to look at when deciding whether there was probable cause that the cell phones were in fact tied to the crimes in some way. The second fact, which is closely related, is his girlfriend Lisa Parton's deception about his cell phone use. So when law enforcement talked to her shortly after the murders, she lied and said that she had not spoken to Archey since the night before when he got mad at Mr. Mark Oakley's house and broke his phone, is what she said. But we know that he didn't break his phone because, again, based on her phone records, there were phone calls that went back and forth between her and Archey after the murders. And so a reasonable inference to draw from this fact, which was included in the affidavit, is that the defendant's girlfriend was possibly concealing evidence, or she might have thought that there was incriminating evidence on Archey's cell phone, which would explain why she was lying about this. So at first, we've got the timing of the cell phone use, we've got the deception by the defendant's girlfriend. We also have evidence in the affidavit that there were at least 2 accomplices that were involved in these crimes. One of the witnesses that police said that they interviewed, Smotherman, she mentioned that when Archey was there at the house and had taken her outside briefly, he mentioned that there were 2 other brothers being in the room. And so a reasonable inference to draw from this is that there were accomplices involved. Smotherman could even hear one of the victims pleading for her life in the other room when she was taken back inside the house. And then Archey himself, when he's being interviewed by police, he claims that there were 2 kidnappers that had just taken him to the crime scene against his will. So that's another data point that we can consider, where there was, even by his own admission, there was 2 other people that were apparently involved in this criminal episode. And as the U.S. Supreme Court mentioned in the Riley versus California decision, it's general knowledge now that people use cell phones when they're facilitating coordination and communication among members of a criminal enterprise. And so that's why in Riley versus California, the Supreme Court said, despite that concern, you still need to get a search warrant before you search a cell phone generally. I know that case involved the search incident to arrest exception, but the through line of that case is we're still going to require you in most cases to get a warrant when you want to search a cell phone. Well, that's exactly what happened here. Police went to a magistrate, they got a warrant, they established probable cause connecting the cell phone to the crimes. And we cited several cases from other jurisdictions in our brief where when there's accomplices involved, that increases the likelihood that this defendant was likely using his phone to communicate with other people involved. It's not enough just to simply say, well, I suspect that you committed a crime and I know you have a cell phone, therefore you probably have evidence on your phone. That's not what we're saying. We're saying there's very discrete facts that are alleged in this search warrant affidavit that make that evident, that there was evidence on the cell phone itself. And the fourth thing that we've discussed in our brief that kind of ties all of these things together is the training and experience of Investigator Reed, who drafted the search warrant affidavit. And he concluded the affidavit by emphasizing that he had been in law enforcement for over 10 years, I believe, and that based in his opinion that these, the facts that he had alleged indicated that the cell phone possibly had evidence of first-degree murder on the phone. And I know the defendant kind of focuses on the word possibly that he uses in that part of the affidavit, but we have to remember that we're construing the affidavit in a common sense and practical manner. And an investigator is not a trained attorney. It would have been helpful, I guess, for me if he had said, based on these facts, I think there's probable cause to believe that there was evidence of first-degree murder on the phones, but we don't require that type of precision from a non-lawyer. So I think when you read the statements that he makes there at the end of the affidavit, and you read them in a common sense way, you can see that what he's saying is, based on this evidence, and in light of my training and experience, I do believe that there's evidence of the murders on the cell phone. I think that's the fairest reading of that. And looking at those 4 different categories together does establish probable cause. Now, the defendant in his motion to suppress filed in the trial court focused a lot on the McLaughlin case from this court, and the trial court didn't expressly rely on that decision in its written ruling, but I did want to distinguish it in case the court finds it helpful. I think it's distinguishable from this case in 3 ways. First, in that case, it was a suppression case involving a search of a cell phone. However, this court's opinion was really decided more on overbreadth grounds rather than the probable cause of the search warrant affidavit. So overbreadth is a matter of whether the search warrant itself fails to satisfy the particularity requirement of the Fourth Amendment. It's not a matter of whether the search warrant affidavit included enough facts to establish probable cause. Now, there does need to be a match between the things that you establish probable cause to search and what you're actually allowed to search on the search warrant. But here, the trial court's ruling rested solely on the probable cause finding. It didn't reach the issue of overbreadth. So the case is distinguishable for that reason. But even if you were to look at McLaughlin and look at what probable cause supported that search or lack thereof, the state's affidavit had only really alleged that the defendant possessed the cell phone at the time of the crime and used the flashlight function on the phone. And the affiant in that case, I think, just asserted kind of a bare belief that he thought the phone would have evidence of a crime. But here we have much more than that. Again, we have the timing of the cell phone use, the girlfriend's deception about contacting Archey with her phone, and the existence of other accomplices. So I don't think that case does much for the defendant. And of course, we also had other accomplices, whereas in McLaughlin, there was a single suspect involved in a homicide. So we do think the court should reverse the trial court's suppression ruling based solely on this determination that there's not enough probable cause to support the search warrant. We think that was erroneous. However, if the court were to disagree with us about that, we've also advanced this alternative argument that the court could adopt the Leon good faith exception to the exclusionary rule. And I recognize that there's a couple of opinions from this court indicating that it believes that this court, as an intermediate court, might not have authority to adopt or recognize new applications or exceptions to the exclusionary rule that the Tennessee Supreme Court hasn't fully explored or adopted yet. And obviously, I disagree with that, and we've advanced some arguments that maybe the court hasn't considered before that I think would be helpful to think about. But another reason we've briefed this issue is that Judge Easter, even in the Reynolds case, when the court previously said, we don't need to reach the issue of whether the good faith exception applies, and we don't have the authority to do so, but we recommend that the court basically look at this. It would be an appropriate case, I think, is how the court put it, if it were to go up on further review, and the Supreme Court did so. So that's another reason I wanted to brief this issue, just in case the court wanted to include language to that effect in its opinion. But I did want to emphasize that in Leon, which was the original good faith exception for relying on a search warrant that was later found to lack probable cause, that was the original good faith exception recognized by the U.S. Supreme Court. And even in that case, the Supreme Court had said in its opinion that the Fifth Circuit Court of Appeals had adopted that good faith exception even before the Supreme Court had. And it didn't say that the Fifth Circuit kind of overstepped its authority or anything like that. It just observed that as an intermediate court addressing an issue of first impression, there had already been one court of appeals to address it. And it cited that approvingly. Now, it did say there's other circuits that have decided not to go there just as a matter of judicial restraint, and that's commendable, but there was no bright lines about the authority of the intermediate court to either address it or not. So I think that's instructive. We've also cited a Tennessee CCA case and also a Supreme Court case, the Adams decision, where you had another common law rule, like the exclusionary rule is a common law rule created by the courts. And in Adams, you had the marital communications privilege, which is a common law rule that shields, as an evidentiary matter, communications between spouses. But this court recognized an exception to that as a matter of first impression in Adams, or in a predecessor case, saying, okay, but we're not going to apply that privilege if the communications arose from an act of violence against a child. That communications like that are not going to be privileged. So that's an exception to a common law rule. And then you had the Tennessee Supreme Court later on basically adopt that holding and ratify it and say, yep, we agree with the CCA that should be an exception to this common law rule. So I think that's another example from our own state where this court has demonstrated a willingness to address issues of first impression that arise in a constitutional law context where there's not a contrary statute or Tennessee Supreme Court holding that would prevent it from developing the law on this matter. So if the court were to, again, disagree with us on the probable cause issue, or if it simply wanted to provide further guidance to parties or future reviewing courts, I think that might be something to explore in the opinion. I'm happy to address other questions, but otherwise I can come back before you on rebuttal and clear up anything that I need to. Thank you.
All right, thank you, General. Good afternoon, Mr. Justice.
Good afternoon, Your Honors. Drew Justice for the defendant, Ronald Archey. Probable cause is supposed to be evidence that would justify a prudent officer of caution in believing that evidence will be found in the location to be searched. Here, the affidavit gave us no reason to believe that evidence would be found in the phone. And in fact, the officer didn't even claim to believe that evidence would be found there, or even that it was likely that evidence would be found there. Instead, the officer just said it was possible that evidence would be found there. The state has said that this case, if we were to adopt the state's rule as the trial judge said, it would basically mean that you can search a defendant's phone in every case. Now, the state has said, well, it's not every case we want to be able to search your entire phone. It's only the cases where there are accomplices involved. I can virtually not virtually, a huge subset of all criminal cases are going to involve accomplices, so that would still not really limit the rule very much. But here, the affidavit did not provide any evidence, any allegations that Mr. Archey used his phone during the crime or during the incident where he was present. It didn't provide any evidence or allegations that he even possessed his phone at that time. And it didn't even provide any clear allegation that he had any accomplices. Even the evidence that he was even an accomplice himself or a criminal himself was somewhat vague and sketchy. What the affidavit did say was it had a statement from one lady, Ms. Parton, who said that Mr. Archey was guilty of murder and that he had acted alone and had shot both victims himself and had confessed to it. And this is the same lady that the state is now saying, well, now we've got proof in the affidavit that she lied, and they're trying to show that the fact that she lied, that's helpful to them, even though she's the only one that really even pointed to him as even being a criminal at all. Other than that lady who said that he acted alone, that he did the crime but he acted alone, there was another lady, Ms. Smotherman, who said that Mr. Archey was present at the scene, but that he didn't do the crime. And he did refer to the mysterious term brothers, which we don't know what that means. He doesn't say, I don't think the affidavit uses any language that's saying they're my brothers. It says they're brothers, and so we don't know, like, are these two men biological brothers of each other? Are they adopted brothers? Are they just calling each other brothers because they know each other? Or, are they members of a gang that uses the term brothers, such as the Aryan Brotherhood? There's just nothing in there that even says that they are accomplices. But, frankly, there should not be a rule that says just because you commit a crime and you own a cell phone and you have accomplices, that's enough to search your phone and get all the data off of it. There just should not be such a rule. And so even if the state could show that he possessed his phone, which they can't during the crime, even if they could show that he did the crime with accomplices, that should not be enough. In the case of United States versus Bass, which the state relies on, in that case, it was a much more narrow type of search warrant, because in Bass, you had the police just trying to open up the phone and get the phone number. And that was in a case where the police knew that it was like a scam that was going on, where phones were used. They knew that it was an ongoing crime that involved the use of cell phones, that it involved multiple accomplices, and they specifically put forward evidence that the defendant had seemed to not exactly resist arrest, but evade arrest in a sense, and seemed to be dialing a number, and they put forward at least a plausible argument that he was dialing his accomplices. And so that was all they had. And even with that, they didn't get all the data from his phone. They just wanted to get his phone number. What they said in that case was, at trial, the arresting officer testified that his search of the phone involved turning it on and taking a picture of the home screen to obtain its number, which matched calls made during some of the account takeovers. So there they already had phone records, but they wanted to get that phone's number. So I just submit that case is not very helpful to the state, because it was a very limited search. They had way more probable cause that a phone was used and that he was the one that used it to contact his accomplices. In State versus McLaughlin, which we've relied on, the court held in essence that possessing or even using a cell phone, if done in only a limited capacity during a crime or at a crime scene, that is not probable cause to seize all the data from your phone. And in that case, the defendant did possess his phone and he used it just as a flashlight, and the police didn't have any evidence that he had used it in any other way, and so this court held that that was a Fourth Amendment violation to search the whole phone. Here we don't even have any evidence that Mr. Archey possessed the phone, much less that he used it as a flashlight or as a phone or as for any other reason. And we just got to keep in mind the breadth of data that's on a cell phone and the breadth of data that was seized here with seemingly no basis at all. Like, I highly doubt that Thomas Jefferson would tolerate the government coming and seizing all his books and all his papers just because someone accused him of a crime. Maybe it's a crime he supposedly committed by himself, or maybe it's one he committed with accomplices, or maybe it's one where one lady says he did it by himself and the other lady says he's innocent. The founding fathers would not have stood for this, and this court shouldn't stand for it either. Now,
I understand from the state's argument that there are two specifics and sort of two general factors that they say support the search warrant. One was that the timing that they obtained the girlfriend's phone, and they showed phone calls to her from the defendant's phone. Were these before and after the offense? Do you know?
I don't think it specifies. I think I would assume, or the way I read it, I think was just that they were after, but I don't think it really says.
All right, and then deception by the girlfriend, that she said he broke his phone, that type of thing. So that indicates she's perhaps trying to hide something. So those were the two specific factors that they sort of argued, right?
I guess so, yes, sir.
And then the general ones that other people were involved in conspiracies or multiple criminal enterprises, cell phones are often used, some kind of general term, and that the training and experience of the affiant officer. Those are sort of the four things that I understood that showed that this warrant was reasonable. So where do you differ in those four?
In terms of I don't think the training and experience of the officer is really supposed to mean much at all. That's just sort of a bare criterion that is supposed to be included. But I mean, under Nathanson versus United States, there's a specific case saying that an officer saying that I sincerely believe that evidence of this is going to be found at this location, that's not enough for probable cause. And that's basically what just relying on the training of the officer is. And here we don't even have him saying, I sincerely believe it. We just have him frankly acknowledging, well, there's a mere possibility that this fishing expedition might come up with something. And then in terms of the girlfriend's comments, I mean, she's the one, there's no allegation in the affidavit that the girlfriend was involved in murdering her own daughter. And so there's just saying that he spoke to her at some point after the crime really has nothing to do with communicating with an accomplice. And then I think I forgot what the rest of Your Honor's conversation was, or question was, but.
Of course, when it's almost like your book example. Looking at the cover, you're not going to know what is inside the book. And so you have to get a search warrant to look inside the book. Maybe that doesn't give you the right to look in all books. But in a search phone, it's sort of, a cell phone is sort of similar. They have to get something to get into the phone. And, I mean, search warrants I remember looking at, or as a judge, are usually based on some type of communication from that phone before or after the time of the crime. That's the first thing you look at. And then who are those communications with? And those are sort of the two of the things the state seems to be arguing are important to this warrant.
I mean, I could easily envision cases where you could have a more substantial and actual showing of probable cause. For example, you could have just a witness say that, these individuals were meeting together and I saw them using their cell phones to talk to each other. You could have a suspect who says, we met up at location B and then traveled to location A, and we were texting each other to figure out what our plans were, and so you could easily have probable cause. You just can't just sort of assume probable cause just because someone owns a cell phone. And again, here, we don't even have any clear statement that he even had any accomplices, much less that he specifically communicated with one. Now, the state has, in terms of the good faith defense, I still contend that good faith has been waived here. And I acknowledge that the words good and faith were used, but the state did not cite Leon versus United States or any other case, and they didn't actually argue good faith. What they said was the words good faith and then launched into the doctrine of inevitable discovery. They said, Your Honor, the other issue here is there's been good faith reliance on the issuance of this search warrant. Had this search warrant been denied, there is other evidence that was available potentially at the time that we gathered later that could have been supplemented to go and seek another warrant that clearly indicates the phone was used. And had it been denied, had the magistrate said we're not issuing the search warrant, we would go and continue our investigation and seek another search warrant. And so what they're talking about for good faith is they're just saying, like, basically it's unfair to handicap us now because we would have been able to produce a better search warrant if this had been denied. And that's not what good faith is talking about. That's inevitable discovery. Finally, I would just submit that there has been no good faith. There isn't any good faith present here. Here, the affidavits didn't list any meaningful reasons for why evidence would be found on this phone. It expressly just used the terminology of possibility. And I submit when you take those 2 points into account, this is a bare bones affidavit, even under Leon. And then you've also got to take into account that McLawhorn was already decided a year or two prior to this. And so the officer, if he's really as well trained as he claims, he should have been on notice and known to apply McLawhorn and come up with some actual facts for why he should search all the data of a phone rather than just saying, well, the defendant owns a phone. And so no good faith was present here. I do submit that it was a bare bones affidavit. Further, I would just submit that I guess this court or the Tennessee Supreme Court could sort of do whatever it wanted in theory in terms of defining what good faith is. But as I've argued in my brief, the Tennessee Supreme Court seemed to define good faith as something that the state has to prove and prove specifically with evidence. And most notably in State versus Lowe from 2018, the Tennessee Supreme Court said that under our good faith exception, the burden shifts to the state to establish by a preponderance of the evidence that the technical noncompliance was the result of a good faith error. And I guess this court, could always just say, well, for maybe reliance on a warrant, we're not going to require any burden of proof or by preponderance or any evidence at all or any subjective good faith. But I mean, if we're going to follow the pattern from Lowe, and that's cited approvingly in State versus Eldridge too, I do think the state should have to prove good faith under our Tennessee law, and they simply did not do that. The officers didn't testify at all. As I said, good faith really wasn't even argued at the trial court below, much less proven, and that's, I submit, why the trial judge didn't even make a finding about good faith one way or the other, because it wasn't even really squarely put before him. Ultimately, I submit that we shouldn't have to get to good faith, and the court should not adopt a good faith exception because it tends to just eviscerate the Fourth Amendment, and that's what's happened at the federal level when they have this expansive good faith exception. And even if you want to say, well, the Fourth Amendment is it's not supposed to be about the court's jurisdiction to only hear righteously obtained evidence. It's instead, it's only supposed to be about, we're going to impose the exclusionary rule to deter police misconduct. Well, where's the deterrence of police misconduct if the police know that they can do just about anything and there's very little chance of it ever getting suppressed? And so, even even just for deterrence purposes, I just submit good faith is a bad idea and this court should not adopt it. But in any event, the Fourth Amendment was violated, and I would submit that the judgment should be affirmed.
Thank you, Counselor. Rebuttal?
Yes, Your Honor, just a few points. So opposing counsel has repeatedly said there's just no evidence that Archey used his cell phones in connection with these crimes based on the affidavit. But really, I think what he's arguing is that if you're looking at the factual allegations in the affidavit and just reading them in light most favorable to the defendant, then there's no evidence. But certainly, we've identified, as Judge Holloway summarized, those 4 different categories of facts that we think supports a finding of probable cause. And if you're reading the affidavit in a common sense manner and thinking about all of these things together, then certainly there is evidence that Archey used his phone in connection with the crimes. The affidavit didn't need to say Archey used his cell phone during the murders to text the getaway driver. That's not what's required to get past the minimum threshold showing to support a finding of probable cause. We're just looking at non-technical probabilities, as the Supreme Court recently said in the Green decision, reasonable inferences, things like that. So we do think that there's plenty of evidence to support the probable cause in the search warrant. Opposing counsel also said a few times that this search allowed officers to search all the data on the phone. And I again want to just refocus the issues here. The trial court's ruling was only that the search warrant affidavit lacked probable cause. It did not make a finding about the overbreadth of the search warrant. So to the extent we're concerned about the search going into other things on his phone that maybe we didn't have probable cause to search, that is a separate issue that's not before the court. That's an overbreadth claim that depends on the particularity of the search warrant. That's a separate issue than the probable cause of the search warrant affidavit. So I think the court should keep those things separate. This court's decision in Hardison from 2023 made that clear. And it explained, too, that to the extent there's problems with overbreadth in a search warrant, the remedy for that is you sever the offending provisions. If it authorized, for instance, a search of someone's social media accounts, but there was no evidence in the affidavit that they used their social media accounts in connection with the crime, then maybe you could sever that portion of the search warrant. That's the remedy for overbreadth claims. And here, the trial court didn't give the state an opportunity to make an offer of proof, so you're not really in a good position to do that on appeal. So we think you should just focus on the probable cause determination. We didn't waive the good faith argument. I had acknowledged the DA just briefly mentioned that at the suppression hearing, but it was preserved for appeal. And for the reasons I've stated, the affidavit wasn't bare bones because we had these 4 different categories of evidence. And the Leon good faith exception really does strike at the core of the good faith exception to the exclusionary rule, because that's what we want officers to do, is to go through the effort of getting a search warrant, and that's what was done here. So I see that my time has expired. If the court doesn't have any questions for me, we ask you to reverse the trial court suppression order.
All right, thank you, General. Good arguments and excellent briefs. We'll take it under advisement. Call the next case, please.
George W. Cozy versus State of Tennessee.